Welcome to another George Consortium COVID-19 Law and Policy briefing presented by our colleagues around the country in association with Public Health Watch at Northeastern University and the Center for Public Health Law Research at Temple University. We are here to provide expert legal analysis during the COVID pandemic and hopefully to answer some of your questions. I'm Abraham Gutman. I'm an opinion writer at the Philadelphia Inquirer. And today with me to talk about religious freedom and COVID-19 is Claudia Haupt, an associate professor of law and political science at Northeastern University. Her research is focused on the First Amendment, and I'm very excited for this conversation. So let's just dive right in. There's been a lot of conversation about religious freedoms and COVID-19 recently, specifically around issues with whether or not going to church, going to synagogue, going to mosque is something that should be allowed under social distancing. This kind of all came up to a head last week when the Department of Justice sent a letter to the governor of California that I kind of hope in this conversation we can understand together, if you can help me understand how simple things are. The letter says that simply put, and I'm quoting, there is no pandemic exception to US Constitution and the Bill of Rights. On the other hand, it seems that things are not so black and white. We know from former Justice Robert Jackson that kind of coined the phrase that the Bill of Rights is not a suicide pact. So I'm hoping that we can help us understand where is the middle between those two and how much should we think of the Bill of Rights as something that public health should not take into account at all. So let's start off. What have been some of the major issues in religious freedom during COVID-19?
Yeah, so let's start with a very basic question, right? So can the government require that churches be closed or restrict attendance of religious services, right? How many people are allowed into a church or a synagogue or a mosque at any point in time, based on public health concerns, right? After all, the First Amendment guarantees free exercise of religion, right? But you just quoted Justice Jackson, and none of the rights are absolute, right? And there are limits, and the same goes for the free exercise of religion. So there's a long and somewhat meandering doctrinal history in which the Supreme Court has interpreted the religion clauses. And I will say that what makes this area of the law particularly interesting is that it's sort of constantly in flux. And so to answer the question of whether the government may require houses of worship to close, the short answer is yes. Of course, it has to be sufficiently justified in doing so. And so we can talk more about what the constitutional analysis or potentially also statutory analysis would look like in this context. But the short answer is yes, religious freedom can be limited. Now, of course, we're also seeing elected officials press, as you just pointed out, right, press more or less aggressively for the reopening of houses of worship. And certainly there's a political dimension to this. Right, and so this is where we see perhaps even just a partisan calculation that sort of open the churches, right, will resonate with certain portions of the electorate. And so I suppose it remains to be seen, though, whether this calculation actually works, right? So it depends, on the one hand, it depends on, does this resonate with anyone who would not have voted one way or the other already? It also depends on, whether individuals actually want to or choose to attend services, even if houses of worship are back open or can, or there's no limit on how many people can go there, or maybe they're just more hesitant. And so, finally, I suppose this is also a matter of common sense, right? So the last thing that religious communities will want to do is get everybody sick. And so, even this may be seen as kind of a political issue in some corners, or as a way to score electoral points with certain groups of voters. The truth is that here, as in so many other areas, right, a little common sense will go a long way. And so that's sort of a broad overview of kind of this specific moment in time.
Yeah, thank you for that. I want to get to the common sense point a little bit later, because as you were talking, I have a bunch of questions about that. But you mentioned statutory analysis, and I wonder if you can kind of help us understand what are the laws that govern this. I think a lot of people who are non-lawyers like me are familiar with a notion of a First Amendment, but aside of the First Amendment, what else are judges, states working on, and how much of this is local, like on the state level versus the federal level?
Yeah. So we'll have to dive into a little bit of constitutional history, take a little detour through kind of constitutional history to answer that question. So bear with me. Perfect. I will come back. I promise I will come back to COVID. This is just sort of a little bit of a meandering through the First Amendment. So, all right. So we have to start basically back in 1990. There was a case in the Supreme Court called Employment Division v. Smith. And so the case was about individuals who ingested peyote as part of a Native American ceremony in violation of the state's drug laws. And they claimed an exemption from these laws and based on freedom of religion, right? These were not specifically targeted at religion. These were just generally applicable drug laws. And their claim was, well, the state didn't have a strong enough interest at the time that the Supreme Court actually demanded a compelling interest in prohibiting peyote for religious use, right? So you may have general drug laws, but you really don't have a strong enough interest to prohibit this for a ceremonial use. And the Supreme Court said, actually, no, under the Free Exercise Clause, you don't have a claim to an exemption from an otherwise neutral, generally applicable law, right? Applies to everybody, religious, non-religious. You don't have a claim under the Free Exercise Clause. And the law in question here was just about controlled substances, right? This was across the board, no matter who used them. So this was neutral, generally applicable, and Justice Scalia wrote the majority opinion in Smith. So the result was there's no free exercise claim to an exemption from a neutral law if it's generally applicable. It's different though if you're targeting a religion specifically, right? But that wasn't the case here. So we're talking about a law that applies equally to everyone. So Justice Scalia said in Smith, look, if you want an exemption, right, go to your state legislature. Just say, hey, you know, we want this for religious use. But so go to your state legislature, but don't come to the courts, right, and demand an exemption as a matter of free exercise. So that's Smith, right? After Smith was decided, everyone hated it. And by everyone I mean Congress. So they passed federal law pretty much unanimously, actually. It was unanimous in the House and was near unanimous in the Senate. And it was called the Religious Freedom Restoration Act, right? RFRA for short. And President Clinton signed it. And it was supposed to restore this more stringent free exercise clause standard that existed before Smith. It's a little more complicated than that. There's actually debate over what exactly it restored, right? Mm-hmm. A long time ago, the test was more stringent. Was it like the day before Smith was decided, right? Stringent, right? And you actually find some of this. In the footnote, in a footnote in Hobby Lobby, where they're going back and forth about what actually was restored by RFRA. But generally, so leaving that aside in the interest of time, the general idea was, let's get rid of Smith by enacting the statute. Okay, here's where things get really messy. If you've been following along so far, this is where it gets complicated. So RFRA was supposed to apply on the federal and on the state level. Mm-hmm. Okay, that's what Congress wanted, but the Supreme Court in a subsequent decision said, not so fast, Congress, right? You can make this applicable on the federal level, but you can't enact this against the states. So RFRA was unconstitutional as applied against the states. So now you have RFRA on the federal level. You can use it if you want to challenge, for example, say totally random, you have a freedom of religion-based challenge to the Affordable Care Act, totally hypothetical.
Right.
Right. That's where that would matter. So back to COVID. Sorry, this took a little.
Can I just pause you for a second?
Sure.
So just so, again, to make sure that I understand, hopefully this will be helpful. So up until 1990, you could argue these exemptions. You could say, hey, like, this is my religious freedom. First Amendment is kind of, gives there was not a strict objection for these exemptions for neutral laws. 1990 comes along, Supreme Court says, not so fast. Like, actually, that's not exactly how it works.
Right. As long as, so this is for a judicial exemption from a general law, right?
Right.
It has to be applicable to everybody.
Right. So a drug law in this case.
Right, for example, right? A drug law, or, coming back to the COVID context, right? A general sort of stay-at-home order, broadly applied, right? You don't have a specific targeting of religion involved, right? As long as it's generally applicable. You can go to your legislature and say, don't do this, right? I would like an exemption, but you can't say, as a matter of religious free exercise, I'm going to the courts.
Right.
So again, that was Smith. That is still the law, right? And this is what Congress tried to get rid of and restore a more sort of religion-friendly, if you will,
sure.
inquiry under under RFRA, right? So this is our statutory regime.
So currently, the statutory regime is that if you're challenging a federal law, you have this mechanism in RFRA. If you're challenging a state law, it's much more complicated.
Well, and this is where the story continues.
Here.
So, okay, so RFRA not applicable to the states, but several states have enacted their own RFRAs. So 21 states have their own Religious Freedom Restoration Acts. So it depends on where you are. And then there's another federal statute that it would take a little too much time to sort of fully explore, but just so we know it's there. It's called the Religious Land Use and Institutionalized Persons Act. And that may, in some limited instances, also apply, right? So this is about zoning and it's about prisons, basically. So then what we're left with is basically, if you're on the state level, and most of the COVID orders that we're looking at are on the state and local level, then we're really left with sort of a going state by state analysis. Now, what we could talk about to just make it easier is just what's the most stringent version of that, right? So worst case, from the state's perspective, worst case scenario would be the strictest form of judicial review.
Sure.
So, what's important with that is it doesn't really matter what your level of review is. You can't say, as a general matter, religious freedom wins or public health, right? So there's no way to sort of make that general pronouncement. So you really have to look at the facts of the case and just acknowledge that there are important interests on both sides. And so then you just go state by state, as I said, but in the interest of having a conversation, not going state by state, let's just assume the most stringent version applies, right? So worst case scenario, you're in a state, well, worst case for I guess the government, right? And your stay-at-home order has to pass the strictest form of judicial review, which is what we call strict scrutiny, right? So under strict scrutiny, the strict form would be the government has to have a compelling interest, so it has to be a compelling state interest, and the government intervention, so for example, the order to close houses of worship or to limit the size of the congregation, for example, right, would have to be narrowly tailored. So compelling state interest has to be narrowly tailored, and it has to be the least restrictive means of accomplishing the government interest. So that's the strictest version that.
So if CDC says that you're allowed to have 50 people gatherings and the state comes and says, we're going to limit it to 10, someone could argue, well, you could probably achieve this with 50 and not 10.
So that's exactly where we're going to see the real interesting action in these cases. To what extent are courts going to defer to expertise, right? Traditionally, there was a high, so first go back to compelling state interest, right? Public health traditionally has been a compelling state interest, right? So so what we're really fighting over then is narrowly tailored, least restrictive means to the extent that that's necessary. So I think one of the really interesting points will be, will courts defer to experts as long as the state is following, say, for example, CDC guidance, right?
Sure.
Will the courts then say, that's fine, you have a compelling state interest, and you're doing what the experts are telling you to do? Or will the, and problem, of course, is we've seen an assault on expertise recently. So will courts then say, no, we don't buy what the experts say, right? Will they try to somehow make their own inquiry?
So let me ask you a question about that, because and there was a COVID law briefing on this, so I recommend everybody go back and listen about kind of what is really the powers of the federal government at this moment to enact stay-at-home orders and federal shutdowns and stuff like that. So I wonder how important is, for example, if the federal government now lifts up restrictions, right? They say, we don't have recommendations anymore, like the White House gives out currently. Would that then be a tool in courts to undermine states, being like, look, the White House says this is not, you can achieve this in less restrictive means.
Yeah.
So while they're not compelling the states to use their guidelines because they maybe can't, they do have an ability to undermine them in the courts by basically providing an expertise argument.
Right. So we've seen this sort of battle of the experts in a lot of areas of the law that involve scientific knowledge, right? And so this would be completely unremarkable and not at all related to primarily to COVID, because we've just seen this, over and over again. Just think, tobacco litigation, right? Sure. So as a matter of sort of federal guidance on what states have to base their stay-at-home orders on, there's really very little, right? There's and as we just said, this is all primarily state and local government, and the federal government's role in the stay-at-home closing and reopening the state sort of business has been very little, possibly to the frustration of folks at the federal level who would like things to move in a different direction. And so because it is technically all in the state's purview to regulate, the federal government can't really do all that much. Right. What you're saying is, well, what about the experts? Right, and that's exactly where the problem will be, because if you start having battles of experts in the courts, and you say, well, we have a federal agency that's supposed to deal with this, or we have guidance on the federal level, that doesn't change the science itself, right? So
and we have a history with even the highest court of the land misunderstanding sometimes basic statistics, honestly.
Right. And that, I think, is sort of one of the longer term implications of this will be to see to what extent courts will rely on expertise. Now, this is not, again, this is also not related specifically to religious free exercise, right? You can make this argument with, if you're a shopping mall or if you're a church, right? Huge
issue in college discrimination issues.
It works either way. to sort of decide what the state may base its orders on.
Right.
The way that it comes in here and is relevant is this idea of narrowly tailored, least restrictive means.
We have, sorry, we have about like 2 minutes left.
Yeah.
And I wonder if I can just ask one question to see, I have two actually, I'll try. So the first is, did reading tea leaves on what courts will do is always a dangerous game. Did any court already rule on any of these issues to give us kind of a glimpse to what is to come?
Yeah, so there are a lot of challenges popping up all over the place. So just yesterday, there was a suit filed in district court in Oregon over the governor's limit of how many people can be in a house of worship at one time. So it's 25 people in Oregon. Same thing happened in Colorado, also a suit. There was 10 people. Same thing last week in Nevada. So these are happening all over the place. The more states reopen, the trickier it gets to make this narrowly tailored and least restrictive means argument, right? So I usually tell my students this is like a Swiss cheese kind of argument, right? The more holes you have, the less likely it is that you're going to succeed. And this is exactly where you see the challenges. So they say, look, shopping malls are allowed to open, and nail salons, and why aren't we allowed to reopen churches? And so we had two, just within the last week, we actually had two federal appellate courts weigh in on this, and this was on emergency injunction. So one was in the Ninth Circuit, where there was a challenge by a church against the California order and a local San Diego order. And then there was the Fifth Circuit with a case out of Mississippi. And what happened there was, in the Ninth Circuit, they said, look, we're not targeting religion, right? Remember when we talked about Smith, I said, you're not allowed to specifically target religion. And so the Ninth Circuit said, look, California wasn't targeting religion. This was not imposing a burden only on conduct motivated by religious belief, is what the court said. And the Fifth Circuit said, this is a fast shifting landscape. We really don't want this to be on the appellate level. We want the decision to be made on the district court level. But we're going to tell the city not to enforce the order on the promise from the church that they will comply with whatever guidance whatever limits are imposed on other businesses. So they said, on the assurances that by the church that it will satisfy the requirements entitling similarly situated businesses to reopen. So the point we're at now is the more the states reopen, the more there will be a push by houses of worship to be treated just like any other business in the state. So that's sort of where the action in the courts will be.
So in our last 20 seconds, as a parting thought, since there are so many lawsuits on this, it seems like this is a prime moment for this area of law to develop, for new precedents to be set.
Yeah.
What are kind of the opportunities and risks, or mainly risks, of either broadening Smith or narrowing Smith? Yeah.
Well, I mean, so for anything to happen to Smith, it would have to go to the Supreme Court, right?
Right,
so,
right, of course.
And like as a technical matter, it's only going to be of precedential value in the jurisdiction where it was decided. So you could easily have the Ninth Circuit and the Fifth Circuit come out opposite ways on this. The thing is, these are really fact specific, depending on what the orders look like. So you could have wildly different outcomes. Depending on what, it's 10 people here and 25 people there, and it's different. I think, we already talked about one of the implications, which is the sort of role of expertise. I think that's something to keep an eye on. And then the other thing is, just a bit more speculative, but just keep an eye on what happens to Smith in general. It's entirely possible, depending on the composition of the court, that Smith will be overruled at some point. But what's interesting here is that it's really hard to make sort of general predictions because the sort of on the liberal conservative spectrum, because the political valence over time shifts, right? Remember that it was Justice Scalia who wrote Smith, right? Sure. So that'll be an interesting thing to keep an eye on as well.
I have a million more questions, but we're at time. Thank you so much to Professor Claudia Haupt from Northeastern University. I really appreciate your time. So we will be broadcasting on Twitter at noon every Tuesday and Thursday. All you need to do is go to @PHLawWatch, Public Health Law Watch, or search #COVID Law Briefing. You can Google for the show notes, and all the show will be archived by the Week in Health Law podcast at www.twihl.com. Thank you very much. Thank you again, Professor Haupt. And the COVID-19 Law and Policy Briefing are produced by Faith Halik and Bethany Saxon. We will see you all next time. Please stay safe and wear a mask.